This webinar is on displacing homeless families and how to displacing homeless families, how to challenge out-of-borough discharges in homelessness law. Today we'll be talking about the ever greater strain on local authorities, and more people are homeless and being displaced from their local areas. When it comes to both temporary accommodation and final offers, practitioners are routinely having to challenge out-of-borough placements in neighbouring boroughs, distant suburbs, and increasingly wholly different regions of the country. This webinar will give an overview of the law and current trends in out-of-borough placements and consider the most effective kinds of suitability challenges. The panel will look at recent cases and potential new grounds for challenge, including discrimination and PSED challenges under the Equality Act 2010. I'm Maaha Elahi. I'm a barrister here at Garden Court, and I specialise in housing, immigration, and public law. I always find it really awkward to add anything further beyond that and to sell myself. So I'll go on to selling Nick and Matt, who I'm sure many of you know if you do work in housing law or have worked with before. Nick specialises in representing homeless people, residential occupiers, and destitute and migrant households in both public and private law disputes. He has acted in many of the most important housing law cases in recent years. The legal directories consistently recognise his expertise in this field, as well as his inventiveness and commitment to his clients. Nick has a particular specialism in cases where social entitlements overlap with equality and discrimination law. He has been instructed in many of the key cases in this area, including TM and Metropolitan, Forward and Aldwick, and London and Quadrant and Patrick, on the PSED and in housing possession claims, and Edisotu and Lewisham on discrimination against homelessness applicants. Matt is a social welfare and public law barrister. He has a particular interest and experience in housing, homelessness, public law, welfare benefits, and migrant rights. He has a busy housing law practice and accepts instructions in cases defending possession proceedings, homelessness, housing allocation schemes, and social security issues. Matt's experience in welfare benefits, public law, asylum support, and migrant rights enables him to provide a holistic approach. They are both co-authors of the 7th edition of the Housing Allocation and Homelessness Practitioner's Text, which I'm sure we all use day to day, and that is to be published in early December. They will both be presenting their slides to you. All slides will be sent to all attendees. Please put any questions in the Q&A box, and at the end I will go through them and ask those questions to our speakers. They will aim to ask you answer every question, time permitting. We aim to finish at 7 p.m. and this webinar is run by the housing law team in Garden Court Chambers. So I will pass it over to Matt to start.
Thanks very much indeed, and thanks everybody for attending. What we've tried to do with this session is kind of split the topics into a sort of before and after sort of theme. So what I'm going to try and focus on is how to ensure that suitability and with that location of where suitable accommodation might be can best be tackled before a family is placed out of borough. And then Nick will go on to talk in a little bit more detail about how to challenge decisions once a family has been placed. So we try to split it in a sort of before and after type of session. And I'm going to be mostly focusing on challenges to housing needs assessments and how that can then hopefully feed into, or at least it should do, feed into more lawful, more reasonable suitability decisions and more lawful and more reasonable decisions on locations of properties when families are placed out of borough. If I can ask the slide deck to move along, please, just to start with, thank you. Just to start with then, in terms of the key fundamentals from the Housing Act, which I'm sure most of you are familiar with, there's the general obligation under Section 206, any accommodation offered under Part 7 of the Act has got to be suitable, Section 208, as far as reasonably practicable, local housing authorities shall, in discharging their functions, secure that accommodation is available in their district. And then section 210 gives the Secretary of State power to make an order in relation to suitability, to factors to be taken into account, suitability. Next slide, please. From which we get the homelessness suitability of accommodation order. And in particular today, we're particularly interested in Article 2, which specifies that local authorities must take into account the location of the accommodation when determining whether it's suitable for an applicant. And that includes taking into account the distance of the accommodation from the district to the authority, significance of disruption that would be caused by the location, proximity and accessibility to medical facilities and other support, and also to local services, amenities, and transport. So again, stuff that you would think is relatively sort of common sense, but the realities are not necessarily that this isn't adhered to or followed, but that local authorities will say that notwithstanding these factors being taken into account, that there isn't anything closer that they're able to provide. More on which later, but these are the kind of starting points in terms of the legislation. And then next slide, please. And then a few more kind of key basic principles before we get into it. So we still find ourselves relying on 10 years later the judgment of Mazzola Mesa and Westminster, which sort of emphasizes those key principles that we've just been through. So the obligation to try to secure accommodation as close as possible to the local authority's own district. The idea that if there isn't anywhere within the district, then the obligation is to try to secure accommodation as close as possible. And then I've put here the references to the key bits of the code, so in particular chapter 17 of the code on suitability of accommodation, and those paragraphs there, 49 to 65, are the parts that deal specifically with location. I've highlighted in the last bullet point on this slide paragraphs 54 and 55, which is to do with disruption on things like education and employment. And I've noted here just one line of with argument that seems to come up quite often when you're dealing with families with school-aged children, which is that I often find that reviewing officers in their Section 202 decisions will say that there are a number of schools within a decent travel time of the property that's being offered, and then they will list those schools and the distance from the property. What they don't do, and what I don't think I've ever seen in a housing file, is actually make the inquiries that they're supposed to make with the receiving authority as to whether there are actually places for the kids to take up, which obviously isn't much help. So yeah, it's one thing to list a number of schools within a certain radius of the property, but it isn't much use if there's not actually any places in those schools that the children can take. So that might be something to look at if you've got one of those cases where the children are in education, even if they're not at what is somewhat crudely referred to as critical stages, and if they're not taking exams or GCSEs or A levels, or if or even if they don't have special educational needs, there is still an obligation to follow what the order says in terms of minimizing disruption. What the order says is reflected in those chapters, in those chapters and paragraphs in the code. And yeah, if there's not actually places to take up that are available, then that will obviously be a problem. Next slide, please. So, as I said, in an effort to try and split the topic between sort of before and after, worth just reminding ourselves what is actually supposed to go in a housing needs assessment, the requirements of which are set out at section 189A, and it's subsection 2, an assessment of an applicant's case must include an assessment of the circumstances that caused homelessness or threatened homelessness, so why somebody is seeking assistance in the first place. And then the needs of the applicant, including in particular what accommodation would be suitable for the applicant and any persons with whom the applicant resides or might reasonably be expected to reside. And then finally, what support would be necessary for the applicant and any other relevant persons to be able to have and retain that suitable accommodation. So the idea in the context of suitability then would seem to be to give local housing authorities a roadmap through the decision-making process by having a clear assessment of what would actually amount to suitable accommodation. And indeed, the Court of Appeal has emphasised that that is what that is part of the purpose of a housing needs assessment, is to provide that kind of clear guidance. And indeed, one would think that it would be hard to sustain a decision about the suitability of accommodation that's being provided if the assessment of the accommodation deviates from or is distinct from the assessment of the actual needs of the applicant. So that might be something that you're able to argue in, for example, your representations for a 202 review, or indeed in an appeal in the county court, arguing, for example, that the local authority maybe haven't taken into account a relevant factor, or they've made a decision which is otherwise unreasonable because it departs from a previous assessment that they've made. But that obviously is all after the event, and what you might be wanting to do really is making sure that the housing needs assessment is correct and lawful in the first place, before it gets to the stage of a family being placed out of borough and then having to trawl back through a housing file when they've already had the family's already had the disruption. Next slide, please. I think on that. And how you do that is essentially by judicial review, as has now been established in a number of cases, which I've listed. I've listed the ones that I could dig out for today's purposes here. Just about all of these cases, I think, were brought in the context of the suitability of accommodation that was being provided. Of the ones that I've highlighted there, the case of AN and barking on the bottom is one of those ones where the Court of Appeal where the High Court did emphasize the role of housing needs assessments, not only in providing the guidance to decision makers within the authority, but also more broadly, the importance of those assessments in terms of allocating scarce resources, in terms of trying to manage the best that we can with limited stock and what can be quite high numbers of applicants. Because if the housing needs assessment is done correctly, then decisions on resources can be made more fairly and actually based on levels of need. And so the High Court in AN and barking was keen to sort of emphasise in that judgment that that doing housing needs assessments properly does make a difference on a sort of bigger level, as well as to the individual applicants. Few of those cases probably to highlight just while we're on this slide then. So in AA and Waltham Forest, which is the next one up from the list, one of the arguments brought by Waltham Forest was that a judicial review of the housing needs assessment was premature because the applicant could have challenged the suitability of any property that was offered in a Section 202 review or a Section 204 appeal. The High Court rejected that argument and said that basically where there was reference to decisions that could be made that could be then challenged in a review or an appeal, that was clear within the Act. It is clear that challenging housing needs assessments themselves are not things that are subject to Section 202 reviews or Section 204 appeals. And so the way to challenge an unlawful housing needs assessment is indeed by judicial review. In that particular case, it was held that the PHP element of the document under challenge, so the personalised housing plan, was unlawful because it didn't include reasonable steps to try and assist the applicant in obtaining Part 6 accommodation. It only set out reasonable steps in terms of private sector accommodation. So the PHP was held to be unlawful in that case for that reason. There's then the two UO and Roadbridge cases, which are probably worth just highlighting as well. In the 2024 version, so again, working up the list from the bottom, it was held that the housing needs assessment was unlawful because there was no consideration of the impact of being placed outside of the applicant's area or on her own education or employment, let alone the disruption to the children. And in the 2023 UO case, among other things, the housing needs assessment was held to be unlawful because the local authority had failed to take reasonable steps to actually identify the full extent of the applicant's housing needs. They failed to keep the housing needs assessment under review, despite receiving important new evidence from the headmaster of the children's school. And there was insufficient reference in the assessment to the needs of the children and preventing disruption to education. In addition, the local authority in that case had failed to show evidence that there was no other accommodation that was nearer to the children's school than where they had been placed. I think they'd been moved from, the school was in Tottenham, I believe, and they were moved to Peterborough. And in that case, it was held that the failure to show evidence that there was any accommodation nearer to Tottenham was also a reason for finding against the local authority. So there are a number of ways in which a housing assessment might be tackled, but I think it does come really back to those three factors, and in particular the assessment of housing needs and what would actually amount to suitable accommodation, which in practical terms means that ideally, obviously you want clients to be coming at an early stage so that you could be considering a judicial review before an offer is made or a placement is made out of borough. Obviously that may not always be realistic. None of us have any control over when our clients will seek advice. But of course we have to keep in mind the time limits on bringing judicial review proceedings, and also when the local authority might consider that they no longer need to keep a housing needs assessment sort of live or under review. If, for example, a duty has been brought to an end or otherwise discharged. So it's about being alive to these issues as early as possible, and remembering that you might be bringing a separate judicial review against the housing needs assessment as opposed to a review or an appeal against a suitability decision. I think we can move on to the next slide, please. So just finally on this point, really, so a lawful housing assessment will be one that sets out the nuts and bolts of the needs and what sorts of accommodation will be suitable. And that passage of ZK has been approved in at least 2 or 3 other cases. And that obviously has to include considerations as to the location of the accommodation, not least because of the legislation that I referred to earlier, as well as what's in the code. I think that's that for that one. Next slide, please. So a few cases then, just a few other cases then on challenging housing needs assessments. In Norton and Haringey, one of the issues in this case was that it was argued that there was no housing needs assessment, or there was no lawful housing needs assessment, at least, and therefore it followed that, also it was argued that any decision made on suitability of accommodation must also be flawed. The Court of Appeal didn't agree quite with that argument. So what the Court of Appeal said is that, yes, if a decision is based on a flawed assessment, then the decision itself may also be unlawful. But where a local authority has failed to draw up a housing assessment at all, that doesn't of itself vitiate an otherwise lawful decision of the accommodation being suitable. So in other words, an absent housing needs assessment doesn't mean a trump card in terms of a suitability decision. And indeed, the primary legislation, Section 210, for example, doesn't impose any duty on a local housing authority to consider a housing needs assessment when assessing the suitability accommodation. As I said, I think it's still at least arguable that you could say that a failure to consider a housing needs assessment that has been drawn up may well be a relevant factor that hasn't been taken into account by a local authority. But yeah, an absent or a missing housing needs assessment won't by itself defeat or won't by itself vitiate a suitability decision. Next slide, please. Thank you. In the next case, which I'm going to try to pronounce properly, Fatalhazada and Barnett. It was a similar line of thinking in this case, although slightly different facts, because in this case, what the Court of Appeal said was that if there is a flawed housing needs assessment, which was left unchallenged, so no judicial review was brought and the assessment itself hasn't been quashed, but then the reviewing officer does properly address housing needs, does properly address what would amount to suitable accommodation, then the review decision itself won't be challengeable on the basis of the original deficiency. So in other words, the Court of Appeal is saying that a reviewing officer may be able to remedy or rectify what would otherwise be a flawed housing needs assessment in a Section 202 review. So again, just kind of coming right around to that earlier point about trying to challenge housing needs assessments early where you can, and certainly if possible before a family is placed out of borough or before an otherwise unsuitable property is offered. And what I've done here is to set out why the Court of Appeal came to that view in two paragraphs here. So paragraph 20 is where the Court of Appeal say why they say that the review decision was enough to remedy the problem. Because it said the review decision addressed the suitability of the property and the challenges to suitability in considerable detail, took into account all the detail made available to the reviewing officer, not necessary to provide further details because there was no substantive criticism of the review decision itself. But what is said is that the review decision was invalidated and rendered unlawful by the failure at an earlier stage to carry out an assessment of the housing needs. So in what the Court of Appeal found then was that it wasn't the review decision itself that was under challenge, but it was the idea that because there was a flawed previous housing needs assessment, then that made the review decision unlawful, and the Court of Appeal disagreed with that. And the next slide explains or expands upon that a little bit more. Thank you very much. So as the Court of Appeal says, where a request for suitability review is made and the resulting review decision under Section 202 adequately addresses and thereby remedies the substantive deficiency in the underlying decision, question is whether the review decision can be challenged on the basis of the original deficiency, and the Court of Appeal says no. So it gives reviewing officers a little bit of sort of scope to sort of go back and make corrections as needed. Doesn't mean that you still can't challenge the final decision on suitability, but it's, as I say, it's about whether the original housing needs assessment itself is subject to the county court's sort of oversight if it's been addressed in the review decision. So yeah, next slide, please. And then the last part of my part of the session is just a little bit of an overview on another case on where the appellant at first instance, so the appellant obviously is Miss A, and the local authority was the party that appealed to the Court of Appeal. So where the applicant sought to challenge a decision on the suitability of accommodation based on what the Court of Appeal essentially viewed as sort of technicalities, basically, where otherwise suitability decision was lawful. So what happened in this case was that the two grounds of challenge brought by the homeless applicant were that the local authority had failed to search for available accommodation closer to the applicant's former home, and that they'd failed to comply with the statutory duty under Section 210 to notify the receiving or host local authority within the statutory time limit. Basic facts of this one were that the applicant didn't wish to be accommodated in Enfield itself because there was a risk of violence from her former partner. And indeed, Enfield concurred and assessed that she couldn't be placed in Enfield itself. The applicant had expressed where she wished to be placed for reasons of sort of family and her support network. That included parts of the neighbouring borough of Haringey, and that is indeed where she was placed under Section 193, so under the main housing duty. And in the county court, she challenged the suitability of the Haringey property on a number of grounds, but it included the location and other matters as well as the breach of statutory duty to notify Haringey. Next slide, please. And again, I've just emphasised for ease the kind of key bits for today's purposes. So the applicant had said she wished to be placed ideally in Waltham Cross in Broxbourne or Northwood in Hillingdon. Her solicitor said that the property in Haringey wasn't suitable because the bus route that she used to visit her mother ran through areas where she might be at risk because her ex-partner and family lived along that route or live in the areas that that route covered. The reviewing officer rejected the points about the bus route, not least because there are other ways that it was held that the applicant could have used public transport to visit her mother, so it wasn't the only bus route available. Next slide, please. Thank you. And so when Enfield appealed to the Court of Appeal, and the Court of Appeal allowed Enfield's appeal, this case slightly unusual in the fact that the duty under Section 208 was actually discharged by an out-of-borough placement. And the Court of Appeal gave some guidance on a few other matters as well. So Article 2, what has to be taken into account in the order is the distance between the accommodation and the authority's district, as opposed to distance between accommodation and the applicant's former home. The local authority's supposed duty to find accommodation closer to the applicant's former home was not a point raised in the representations made. And indeed, the Court of Appeal found that there weren't specific objections to the placement in Haringey. And whilst the local authority must take reasonable steps to inform itself, that doesn't mean they're required to, I'm quoting directly from the judgment, scour every estate agent's window between the offered accommodation and the applicant's former address, or to investigate every theoretical possibility, which I suppose in itself isn't necessarily wrong, but I do think you still got the points that we talked about earlier in terms of evidencing where there might be accommodation closer to where an applicant has been placed. So I still think evidence is still going to be key. But yeah, Court of Appeal kind of giving its view about the extent of a local authority's searches. Next slide, please. And then on the breach of the duty to notify the host borough or receiving borough, this is another one of those instances, a bit like with the Norton case on not doing housing needs assessment, notwithstanding that the language to notify was given in mandatory terms. The Act doesn't indicate what the consequence of non-notification or late notification would be. And in those circumstances, it couldn't be said to vitiate the suitability decision. In particular, this is bearing in mind that the notification duty doesn't mean that the applicant themselves is notified. So the applicant themselves is unlikely to be prejudiced by a late or absent notification. Without evidence to show otherwise, it's the host or receiving borough that is owed this notification duty. I think that is about that on my section. I think on that, I can hand over. Thanks very much.
Great, thanks, Matthew. Hopefully everyone can see that. Sorry, there we go. Trouble with out-of-borough placements. There's no great trick, there's no simple strategy for how to challenge them. There's no great unifying principle. It's a series of strategies, borrowing bits from suitability law, from discrimination law, from Children Act law. There are some recurring themes, particularly with children, schools, care needs, and things like that. But this is going to feel a bit piecemeal because we're borrowing lots of strategies from different areas of homelessness law. What I've done is divided it into two things. First of all, we're going to look at the key concepts of out-of-borough placements and suitability, and then go through a series of tips and tricks that practitioners from our housing team have picked up over the months and years when it comes to challenging these placements. There are three sort of sources of the law that are always going to inform the local authority's decision on an out-of-borough placement. Three things that councils will always look at when they're deciding to place someone out of borough and that it's suitable to place someone out of borough. And in order of importance, they are the statute, particularly Section 208, which we'll look at, but also the Children Act duty and the Equality Act duty, which you'll all be familiar with. There's regulations, and again, Matthew's mentioned the Homelessness Suitability of Accommodation England order, with apologies to colleagues in Wales. That's sort of second rung. And then there's the statutory code of guidance. Those three things often interact. They often repeat each other and tread over the same territory. But it's worth, for our purposes, separating them out, reminding ourselves what each one says, and reminding ourselves of how they speak to each other. Where they interact, and the courts have looked at this in the long but very, very illuminating judgment in YR and Lambeth. Those three sources of the law work together to create a strong set of principles. And one thing that I really, really recommend you do, unfortunately, is to read that long judgment in YR, because it's incredibly illuminating. And if we can remember it, and if we can rub it in the faces of every local authority that tries to place children out of borough, then we're doing our clients an immense service. So, Section 208 is the key governing piece of legislation here. So far as reasonably practicable, a local authority shall, in discharging their function under this part, secure that accommodation is available for the occupation of the applicant in their district. Key words there are reasonably practicable and in their district. That's what the law says, that's what the statute says, but as we all know, there is this deepening gulf between the aim of the law, as it was written in 1996 and earlier, and the facts of our clients' cases. We know this gets worse year on year. I've started to hear rumours, well-founded rumours, about the current gatekeeping practice of security staff outside council offices saying, well, there's no point in coming in because they're just going to displace you to Dover, they're just going to displace you to Hartlepool. And obviously that's terribly unlawful, and obviously that's a great, great shame and a terrible disservice to homeless applicants. But the saddest thing about it is that there is an element of truth there. If you've got school-age kids and if you're benefit capped and you're approaching a local authority in London, there is a not inconsiderable chance of you being displaced out of London straight away, and possibly you being displaced there permanently. We see this day in, day out, and it's a great shame. It's a tale as old as time. These sorts of practices go right back to the poor laws in the 17th century. For as long as there have been statutory duties on local authorities, those authorities have sought to escape responsibility by putting people elsewhere. And for as long as there have been social welfare lawyers, we've been standing up to that, and that's what we're trying to do in our casework today. Going back to Nzola Meso, which Matthew has mentioned, 10 years ago, it's a case in which Westminster Council moved some homeless children to Milton Keynes, which felt relatively surprising at the time. I think I seem to remember there were sort of anxious Guardian articles about it back in 2015. But of course, today, Milton Keynes would be a treat for many of our clients compared to some of the places where they've been placed in terms of distance. That's how far we've come in 10 years. This is no longer shocking. This is routine for us, and it's something that we're having to deal with every single day. But this is the key case in determining what Section 208 means and in determining how the Children Act duty interplays with Section 208. And some key principles emerge from the typically humane judgment of Baroness Hale. What she said was, where it is not possible to accommodate in borough, we must nevertheless accommodate as close as possible to the district. So in fact, Section 208 says more than what it says. If we remember what the statute says, in your district if possible. It actually means more than that, as close to your district as possible all the time. So where you can't place in borough, you nevertheless have to place as close as you can. Local authorities must also take account of any disruption caused by the move, but that's not a woolly concept. That's not, we've thought about it. Take account means seeking to protect and preserve existing connections with schools, services, and existing support. So whenever there's an out-of-borough discharge involving children, the local authority should at least be trying to preserve existing links, because that's what take account means in this context. The critical point from Zola Mesa was that the Children Act duty under Section 11 of the Children Act is relevant to these suitability decisions. It was sort of radical at the time. Now we're quite used to seeing, like with the PSED, defensive ritual incantations by local authorities saying that they've had regard to the welfare of the children. But at the time, this was groundbreaking. Children's welfare is the paramount or primary consideration. It's not just something that needs to be bolted on at the end of a review decision. And as Matthew mentioned, that doesn't merely mean that we must think about GCSEs and A-levels, which have been common practice among local authorities. But effectively, every child matters. Whenever you're moving a homeless child to a new district, that's a drastic step. And you must always think about the children's best interests as a primary or paramount consideration. And another sort of groundbreaking point we got from Zola Mesa in terms of the practical effect it's had was the recommendation from the Supreme Court that local authorities ought to have both a procurement policy, how are we going to make sure that we have enough temporary accommodation and permanent accommodation, and a placement policy. When we're placing people out of borough, are we doing that lawfully in a public law way, which means in line with the policy? There's then a spate of decisions after Zola Mesa, and the law develops fairly rapidly in this run of cases. First one is Sully, and the important point about Sully is that this exercise of looking closer to the accommodation, that's not to the existing borough. That's not a once and for all exercise that takes place on the day when an out of borough offer is made. Instead, when there's a review, you've got to look again at the date of the review. Is there anything closer to the borough? But importantly, there's a difference, and this is important, so we sort of need to know it offhand. There's a difference between applicants who accept an offer and applicants who refuse an offer. If you accept an offer and you actually move out of borough, then you've got your sale point, and you can say, well, when it comes to the review, I need you, local authority, to look closer to the borough at the date of the review. If you refuse an offer, Broderick and Bromley the following year says, well, the relevant date for that is the date of the offer. That is a once and for all exercise. So it's important to remember that distinction between acceptances and refusals. We then have Zaman, which follows Saleh, and it goes a bit further and says, well, if you local authority, if you've looked again at the date of the review decision, you've got to actually show that. You've got to evidence it somehow, which felt like a very nice decision. And again, in the first UO and Redbridge case, again, Redbridge covering themselves in glory as usual, that point was made again that there's got to be something that the court can look at to conclude that the local authority has genuinely looked. But this is then qualified in the next big case, which is Moj Kneeling, and the local authority in that had prayed in aid a policy and said, well, this is the way in which we do things. We follow this policy. And the Court of Appeal said that's probably good enough. If you've got a relevant policy, if you can point to the policy, and if you can explain in general terms what you've done to apply it, then that probably counts as your evidence for what you've done to look for authority, to look for accommodation closer to the district. A couple of more points after that. The date of the review is going to be critical, because if on the date of the review there is something nearer to the district, almost certainly the current accommodation is going to be unsuitable. So you really, really have an interest in what the date of the review is. But the courts have repeatedly said, good luck trying to challenge a local authority, the decision about the date on which they make the review. That's going to be very, very difficult indeed. In Elahi and Brent, Lord Justice Lewison talked about the Macabre-ish hope that something might turn up. You can't ask a local authority to make a decision on a particular day. You can't ask them to hold off in case something suitable becomes available. They're going to make their decision on a particular day. And unless they've done something completely extraordinary, it's going to be very, very difficult indeed to challenge the lawfulness of the time at which they make the decision. And finally, in Abdicadia, local authorities are required to do this exercise even where the applicant hasn't raised a point. So they must always think about, was there something closer to the district on the day of the review decision, assuming that the applicant has accepted the offer and moved into whichever far-flung district it is. Moving on from section 208 in the statute, then, the next most important thing is the suitability order, which again, Matthew has mentioned, and I'll just remind you that it's a non-exhaustive list of things that local authorities must take into account. And there are 4 things which I put in shorthand here. They must take into account the distance from the district. They must take into account the significance of disruption, which, as Baroness Hale said in Ptolemaeus, means trying to preserve existing links. They must take into account the proximity to medical facilities and other support, which is essential to well-being, which is a relatively high threshold. And then looking at the new accommodation, they have to take into account proximity to local services, amenity and transport, which is why you will often have a review letter that says, well, there's a bus stop nearby, there's a school nearby, there's a mosque or a church nearby, whatever it may be. And then this suitability order was considered by the courts in combination with the other sources of the law in the YR case, which we'll look at in a sec. And then bottom of the list in terms of those sources of the law is the Code of Guidance. Your friends here are paragraph 1749, 1765. It's fair to say, reproduce a lot of what's already been said in the statute itself, in the decisions that the courts have looked at the statute and in the regulations, but there is some quite user-friendly detail in the Code of Guidance. So it's always worth sitting down with it, making sure that the local authority has complied. And where they've breached the guidance, so for example, there's very useful things like applicants should have a reasonable opportunity to view the accommodation. Applicants who are being placed out of borough should have a reasonable amount of time to think about it. Where they've breached the guidance, you've got a nice point. Because although the statutory requirement is only to have regard to the guidance, one of the nice things that comes out of Nzola Meso is the point that, well, if you've breached the guidance, you're in real trouble. If you've actually breached the guidance, you've got to have very, very compelling reasons indeed for departing from something that the Secretary of State recommends. So again, the Code of Guidance is our friend. And again, this is all wrapped together in that key YR decision, which we're going to look at now. YR in Lambeth was a judicial review. It was a temporary accommodation suitability judicial review, but I would have thought that the same principles apply in a review and statutory appeal. And what the court did was looked at the synthesis between Section 208 itself, the Children Act duty, the suitability order, and the Code of Guidance in the context of a statutory decision. And there are the following principles. Location is a key factor in determining suitability. That's familiar. There is a duty of inquiry into the household's needs. The duty requires local authorities to identify and have regard to the need to safeguard and promote the best interests of the children. Children's welfare must be actively promoted. YR is really good on the Children Act duty. It's not good enough to simply say, well, wouldn't it be nice for the children to have a home? You've got to work out what the duties are, what the best interests are. And then you've got to have regard to the need to safeguard and promote them. It's in principle quite difficult for a local authority to say, well, look, we've got loads of evidence that this child shouldn't move schools for particular reasons. That is their best interests. We're having regard to that best interest, but nevertheless, we're wrenching them from Lambeth and putting them in Hull. It's really, really good on the Children Act duty, and I recommend reading it. And then identification of the need should be explicit. There was a lot of argument in YR about, well, taking the documents in the round, isn't it possible to sort of assume that we've done it? And the High Court gives quite short shrift to this argument and says, no, in the context of a statutory duty to give reasons, which applies to Section 202, You've really got to identify the children's needs. You can't just say something vague and ask the court to infer that it's been done. Some more points from YR. Again, this is familiar. Accommodation must be as close as possible to the district, which is section 208, and there must be a proper evidential basis for saying that nothing closer was available. See Zaman, Saleh, and all the rest. Consequently, if something nearer is available on the day of the decision, the accommodation is deemed to be unsuitable, which is why that date of the decision is such an important point. Local authorities must have regard to the significance of any disruption to education. And this is your key evidence gathering point. You'll always want to be getting a letter from the children's school, a letter from the children's social worker, from clubs, from neighbours, whoever it is, to explain how settled the child is, what impact a move would have on them. And if it's post-move, how badly they're coping, what's gone wrong since they've moved. Because you want to be saying to the local authority that this is the thing that you must have regard to when you're making your suitability decision. And then there is an explicit duty to minimize any disruption to education. So if it's at all possible, a child should not be moved, should not be kept out of school and moved to a different school. And as I say, it wasn't a review decision, it was a section 188 interim accommodation decision, but there's discussion of whether the principles could be read across between the two sort of jurisdictions, and the judge suggests that yes, they can. The principles are the same, whether we're in section 202 or whether it's a non-statutory decision under section 188. Those are the key principles, and I'm going to move on now to my bag of tips and tricks, things that we've picked up. The minded to find procedure is really, really useful, because in suitability cases, there often isn't a section 184 initial decision. Often the offer letter might mention suitability, it might say nothing about suitability at all, but it doesn't have a sort of reasoned suitability decision. And some lazy local authorities think that this means that the minded to procedure doesn't apply. False, it does. The county courts looked at this in a case called El Biri in Kensington and Chelsea. If you want to read it, I suggest you do. It's hosted on Nearly Legal, so we must say our customary prayer of thanks to Giles Peaker, the patron saint of housing lawyers. It's a really good case, and it makes it absolutely clear that the minded to find procedure does apply in suitability. And indeed, it almost certainly applies, because where you haven't got an original decision, almost inevitably your review decision is made on different grounds, because there weren't any grounds the first time around. So it's a really nice, neat point. There's a legal action county court case that suggests that a minded to notice is an unanswerable ground of appeal, where the decision is made on different grounds. So if you've got a review decision and you don't like it, and you're struggling to find something else, the minded to procedure is very much your best friend. The travel to school guidance is also great. It's Department for Education guidance, and it's really aimed at the local education authorities' arrangements for travel to school. It's aimed at things like laying on school buses, active travel plans, how children are expected to go to school. Nevertheless, it is ministerial guidance, it's statutory guidance. It explicitly says this guidance is for local authorities. It may carry more weight when it's a unitary local authority, but it explicitly says that this is who it's for. And there doesn't seem to be a unified view as to whether local authorities ought to take account of or follow this guidance. Some do, some don't, and there are various scraps in the county court about whether it's relevant. What I would say is please, please, please cite the guidance in review representations, because if you've got a local authority that's been shown the guidance and says, yes, we agree, it applies, that's great. If you've got a local authority that pointedly ignores the guidance, then you've got something to work with. And if you've got a local authority that says this guidance is not relevant, then at least we can think about the lawfulness of that and whether that's correct. But if you've not mentioned it, you have a hard time in the county court saying to the judge, well, Your Honour, there is guidance, it's education guidance, we don't know if it applies, and we don't know if anyone's seen it. So please, please, please mention it in a review decision. Because the key paragraph is at 98, as a general rule, the maximum journey time for a primary school child should be 45 minutes and 75 minutes for a secondary school child, including any walk time to a pickup point. Wherever possible, a child should not be expected to make several changes on public transport. It's brilliant because it can often back the council into a corner. If, as typically happens, you've got a primary school child travelling more than 45 minutes to school, then the local authority is stuck, and they can either say, well, we're in breach of the guidance, oh dear, we think it's lawful. Or they can say, well, we're in breach of the guidance, but we think it's reasonable for the child to move schools. And the minute they say that, you trigger everything that Matthew was talking about earlier with housing needs assessments. You trigger everything that's in YR about the need to actively find out whether there are school places for this child, and everything in YR about the need to protect existing education provision, about the need to have regard to promote the interests of the child. So the minute you've got a breach of this guidance, assuming it's relevant, then you've got a very, very anxious Children Act exercise to go through if you're a reviewing officer, which is often vulnerable to challenge. The next is the enhanced suitability requirements for private rented sector offers. It doesn't apply to every type of private sector accommodation. It won't apply to temporary accommodation, but it will apply to a qualifying PRSO under subsection 7AA of section 193. And it's that long list of regulatory requirements set out in the regulations, which you may well be familiar with. They're very detailed and they're very wide-ranging. There's stuff in there about the physical condition of the premises, about the various certificates that the landlord needs, about the licenses that the landlord might need, about the need for a written tenancy agreement, which is often overlooked these days, and that the local authority has satisfied itself that the landlord is a fit and proper person, which includes that the landlord has not breached any provision of housing or landlord and tenant law. So if, for example, you've got what looks like a valid damp and mold claim, you might be able to say, well, how can she or he be a fit and proper person? There's molds there, that's a breach of landlord and tenant law. In particular, the Homes Fitness for Human Habitation Act. There's lots of stuff there, and you will often find local authorities omitting to do this, particularly when there are urgent circumstances and they're moving children out of borough very, very quickly. On the fit and proper person case, there's a nice legal action case recently. Shout out to BHT Eastbourne, Hastings, who raised the point that there's a redress scheme for professional landlords, and that the landlord did not belong to the redress scheme. The landlord was therefore not a fit and proper person, and the review decision was quashed. That's the sort of fun you can have with it if you want to be inventive. And again, Hajjaj and Westminster is a really, really useful case here because of the evidence point. There must be some evidence, not just assumptions, that the enhanced suitability requirements have been complied with. So what you'll want to do when you get the housing file is to sit down with your checklist of the enhanced suitability requirements, go through the housing file. Is the gas safety certificate missing? Is there a written tenancy agreement? If not, you've got a really nice automatic unsuitability finding. Defective offer letters, the lawyer's best friend is winning by default, is winning on a technicality. And unlike the case that Matthew was talking about earlier, the courts have been quite strict about defective offer letters. We've got Norton and Haringey, and we've got SH and Waltham Forest, where an offer letter fails to comply with statutory requirements, the offer is a nullity because those are mandatory requirements and they're statutory requirements. So again, it's worth looking at section 193 and particularly the new subsections under 7AA. Does the letter notify the applicant of the consequences of refusal or acceptance? Does it notify them of a right to review? And the contentious point in the Norton case, did it notify them of the right to reapply within 2 years of the PRSO? This is shortly to be abolished under the Renters' Rights Act, which I'll have to get used to saying. There are rumours flying around of implementation in May, but for the next 6 months at least, your offer letters are going to have to notify the applicant that they can reapply within 2 years of receiving an assured short-hold tenancy. Breach of policy, unlawful policy. As I mentioned, since Nzola Meso, lots of local authorities have a policy, a procurement policy and a placement policy. And Nzola Meso suggests that there might be a jurisdiction in a Section 204 appeal to challenge not just the decision, but the policy itself. Is the policy lawful? And Alib-Kite reminds us that if a decision is taken pursuant to an unlawful policy, then that decision itself can be unlawful. First of all, it's always worth checking, has the policy been correctly applied? I had a fun case recently about what neighbouring borough meant. Does that mean has to share a border or does that mean it has to be nearby? But quite often local authorities just aren't following their own policies. Many will say within a certain travel distance, many will say within this zone, and for one reason or another, they've not met their own policy, and that's a nice straightforward ground of appeal. And it also seems to me that lots of policies themselves may be vulnerable to challenge. If we think about a highly notional local authority that has a vast amount of this accommodation in Hartlepool, first of all, is that compliant with the statutory purpose of section 208(1), which means as close as possible to the district? Because there is almost the whole of England in between Hartlepool and London. How can it possibly be furthering the purpose of section 208 if almost all of your temporary accommodation or permanent accommodation is sourced in Hartlepool? And second, if a local authority appears to be procuring an enormous amount of accommodation in Hartlepool, is that what their policy says? Their policy will probably say something more generous than that. So are they running some sort of shadow policy? Are they failing to apply their own policy? It's worth looking at these policies, looking at what's happening on the ground. And your experience will be really, really useful in making out these cases and thinking about, is this policy actually lawful? Consequently, is the out-of-borough placement in the particular case unlawful because it was made pursuant to an unlawful policy? Section 149, I'm not going to go into this in detail, partly because it's a big subject and there's a great deal of material out there. I've linked to our previous webinar on this from July last year, but mainly because I will bore myself to tears and probably you to tears if I have to go through section 149 again. But our key case here, our best friend, is Lomax and Gosport. That explains what section 149 requires in a suitability type case. It's actually about reasonable to continue to occupy, but that explains what the PSED does in a housing standards type homelessness case. And you will have great success, I'm sure, in running these sorts of arguments day in, day out. We've tended to find that the more unusual challenges have failed. So Biden Waverley was about making highly specific inquiries about the risk to transgender people in particular areas. There was no exceptional duty of inquiry in that case with regard to that particular protected characteristic. And Webb Harnden was about whether moving benefit capped claimants out of borough was effectively a proxy policy. You're effectively deciding, well, if your benefit's capped, you can't be in borough, and therefore out of borough must be suitable. And that failed as well. It was a relatively convoluted argument, and it looked at the generalities of the local authority's practice rather than the specifics in the case. And we seem to have more success on the highly particular challenges of the review decision itself, particularly where it's inconsistent with medical or social evidence. And then substantive discrimination, I wanted to mention this, and this is the last slide to be pleased to know, a case study of a case study recently, Sinway in Lambeth. What had happened in this case was that the gentleman, initially Lambeth didn't accommodate him at all. He was sleeping on an office chair in a relative's living room because there was nowhere for him to go. He had a doctor's letter saying this person needs to be in Lambeth, always in 30 minutes of St Thomas's Hospital. And Lambeth, in fact, refused to make various offers because they didn't meet those criteria before eventually placing him in Finchley. And the geography fans in the room that will know that Finchley is neither in Lambeth nor within 30 minutes of St Thomas's Hospital. And he was left there for 2 years. It was a JR which became academic when he was moved, but the Equality Act claim was transferred to the county court. And the applicant nearly succeeded. The judge found that there was a PCP, specifically a practice. And we got lucky in this case because Lambeth's public records showed that 70% of its temporary accommodation is out of borough. So that was a practice for the purposes of the Equality Act. The judge found that the PCP puts people with disability-related needs at a disadvantage because if you're far away from your treating physicians and your family, it's harder for you to access care in terms of daily tasks, washing, things of that nature. Nevertheless, Lambeth did have policies and mechanisms in place that says we can bring people back into borough where there's a disability, etc., etc. And the judge wasn't prepared to find that this wasn't a one-off. Experienced housing lawyers may be slightly surprised at the idea that Lambeth ordinarily brings people into borough when it needs to, and that this was a one-off. But the judge wasn't satisfied that this was right in Lambeth. The judge found that this was probably a one-off, and therefore the reasonable adjustments were already in place through Lambeth's policy. There's an application for permission to appeal, which we're waiting to hear back on. But I think it's a very, very exciting, the basis of an exciting claim is there, or a series of claims are there, because routinely moving people out of borough does appear to be a PCP for the purposes of the Equality Act. That's going to affect all sorts of protected groups for all sorts of different reasons. And if we can get our ducks in a row, then we can start bringing Equality Act claims. You can't bring them in a Section 204. It wouldn't be a garden court housing team webinar if I didn't embarrass myself by mentioning a case that I'd lost. But RZH and Sutton, which was decided earlier in the year, said, look, if you've got a substantive discrimination point, that doesn't belong in a 204. You've got to bring that in a separate freestanding county court appeal. And that case was unsuccessful, but pursued by the redoubtable Sarah Waller. But it's an exciting line of cases that we can start thinking about with these out-of-borough placements. So the final point, there's no great strategy. There's no great out-of-borough placement trick. But our clients tend to be the greatest sources of inspiration here. They know what's gone wrong, and they will tell us why it's so particularly unsuitable for them to have been moved to Hartlepool or whatever it is. And it's our job to think carefully about what they're telling us and see if we can't cobble together a point of law or a point of practice to prevent it. So that's me. Plenty of time for questions, which hopefully we've got some in the chat. And if not, please do put some there.
Great, thank you, Nick and Matt. I found that really helpful, like a helpful legal background, and then also the tips and tricks were really good to know. So someone asked what a PCP is and what is its effect. So if you can give a brief overview, that would be helpful.
Yeah, so for the purposes of the Equality Act, if you want to bring a discrimination claim either under Section 19, indirect discrimination, or under Section 20, reasonable adjustments, you need to show that there's a provision, criterion, or practice. And that's got quite a generous definition. And practice, we tend to think about PCPs as policies, but practices are also challengeable under the Equality Act. So in that particular case, the practice was placing 70% of homeless applicants out of borough. And that's a practice that many, many London local authorities will have, even if they don't put it in quite so clear and transparent terms as Lambeth did. But that's a term of art for Equality Act challenges.
Thanks, Nick. The next question is, can the Department of Education guidance about travel be used in Section 17 cases? I'm not sure if that's
yeah,
either of you know. Yeah.
I wouldn't have thought there was any reason not to, for the same reasons that Nick went through when he covered that topic. So if you're challenging, the lawfulness of a placement under Section 17, then I can't see why you wouldn't be able to rely on that. And again, as Nick said, if a local authority either says it doesn't apply, then that might be an avenue of challenge in itself. And if they say it does apply and we're in breach of it, then the kind of tangential points that would flow from that might give you something to work with.
Thank you. Next question, where clients from a particular background and particular like social or cultural background, and they're being moved outside of the area where they have strong connections, is that something that can be raised in these sorts of challenges?
I've been thinking a lot about this recently. It was a very hot topic for obvious reasons during the race riots recently, and we were running quite a lot of urgent cases about clients who felt particularly unsafe in towns and cities where riots have taken place. That has cooled now, but there is a really interesting question about things like areas with reform councils. If you have people, particularly recent migrants and refugees, if you have people under the protected characteristic of race in a heavily reform area, do they have an argument that the PSED requires consideration of that type of out-of-borough placement? There's no clear answer. They're very, very difficult cases. I think they're certainly worth raising, and on certain cases, on their facts, might be worth running. But I think it's a huge question, and it's a very, very important one.
Yeah, I was thinking, wasn't there? Is it Gowie? The case from might have been early this year or end of last year, which was to do with it was a kind of human rights point raised on religious grounds, wasn't it? It was a particular type of Was it a particular type of mosque or religious school that the
It was
applicant
about
wanted?
faith schools, the right
Yeah,
to go to faith schools.
yeah, which didn't succeed basically on the basis of suitability. But what I'll do, I'll put the citation for that one in the chat because that might be worth looking at just to give you a little bit of guidance. But I'll dig out the citation for that one.
Great. And when children are in temporary accommodation and they're taking exams in a school far from where they've been placed, is it the family's responsibility to prompt the council to fulfill their statutory duty, or is the council expected to make this effort without any requests from the family?
Well, there's theory and there's reality, isn't there? I mean, in reality, if you've got a child who's particularly if they're in breach of the travel to school guidance, then yes, the local authority should be moving heaven and earth to bring them back into borough if they're sitting exams. In reality, we know that we're working very, very hard. And one of the things which I meant to say, but I've forgotten, is the reason this is such an important subject post Al-Kundi is that the practice seems to be councils have noticed that the minute they decide something is unsuitable, they can be challenged by JR. So their first strategy is to refuse to make a decision on suitability. And one of the big struggles we're having at the moment is forcing councils to even make a decision about whether something's suitable. The next step is they decide it is suitable. So then we have to challenge that decision. And it's only when we get to forcing them to decide that it's unsuitable that we can bring our Al-Kundi JR. So it really is a war of attrition. In principle, councils should be bringing people in, but in practice, the reason you exist and the reason why you're all working so hard is because they don't.
Great. Next question. How will you be able to ascertain what property the council's housing stock, ascertain what properties are available in the council's housing stock and the areas that have been placed in order to challenge that a closer offer should have been made?
I mean, ideally, you'd have raised this point in review representations if possible, and then the answer would hopefully emerge from either what's in the review decision itself or later on when you get the housing file. So after you've lodged your appeal and the court's made its directions as to when the full housing file has got to be disclosed, and then you can look into that and see if you need to amend your grounds at all. I suppose the other option would be, if it's not in the housing file, would be to potentially seek a subject access request or freedom of information request, and see if that gets you any further. If you have a particular practice where you find you're doing a lot of cases against one local authority or one or two local authorities that you're working with a lot, then that might be worth doing anyway, even if you don't have an individual case in front of you, so that you've got something to go off. But yeah, usually the answer will be in the housing file, where you'll be able to see if there's any records of any efforts to find accommodation closer to where it's been offered.
Thank you. Back to equality law issues. So with identifying discriminatory practices, how would you go about proving them? What would the evidence gathering process be like?
Well, that question has touched a sore nerve. If any of you have seen the recent RR and Enfield decision from the Court of Appeal, which came out last week, it was exactly about this. That was an allocations case, but it was about whether we could prove that people with disabilities were waiting longer for council housing than people without disabilities. It looks obvious because if you can only bid on level access accommodation, then you've got less chance than someone who could bid on any accommodation. But the lesson learned from RR and other cases like it, like Willett and Eastbourne, is that you do need to go above and beyond to prove this. So what you'll want to do is get as much public information as you can. If there are any public reports from Shelter, from parliamentary committees, if there's any academic research, and if you can't, then your experience is going to be really useful. You'll want to make a witness statement yourself as a solicitor saying, look, I see this a lot. This is what's happening. I can't say very much because I'm not an expert, but I can say enough to trigger what we call the reverse burden of proof under Section 136 of the Equality Act. So anything you can, as much as you can, but at least something to give a sense that something is going wrong ought to be enough.
And what should be done where there is like a larger household? So obviously there's less stock for larger properties. Should allowances be made in terms of the lack of availability of larger properties?
I mean, the legislation that we went through doesn't make allowances for that. So the obligation is still to find suitable accommodation either within borough or as close as possible to borough. So that's the first part of that answer. So the second part is that obviously the local housing authority will need to know what would amount to suitable accommodation, which is why we started this presentation with doing a proper housing needs assessment. So you kind of do the search from there, I suppose. So what is suitable? Are you going to need a 4-bed, 5-bed? Is the property going to need certain adaptations and so on? And then you look within borough and then out of borough and then next borough along, next borough along, next borough along kind of exercise. So as I say, it goes back to the suitability, but the legislation doesn't allow for property type in terms of finding accommodation as close as possible to district.
And I would only add to that that one of the things they have to look at under Section 210 is overcrowding under Part 10 of the 1985 Act. So if it is genuinely impossible to find accommodation in, for example, London, which is big enough, fine, you'd have to look elsewhere. But what you can't do is put them in a small house somewhere else, because then they would be overcrowded and it would be very, very difficult to justify that as suitable. So overcrowding matters for the purposes of suitability.
In terms of employment, what are the laws surrounding parents having to travel far for their current jobs after being moved into temporary accommodation?
I mean, the code of guidance isn't just about disruption to education. It does also specify things like disruption to employment. So the local authority is obliged to consider things like, whether it affects your, your travel time, your commute, whether you can manage things like other responsibilities that you might have in addition to employment. So can you manage, the school run in your new placement and then still get to work on time? That will have to be a factor in terms of suitability of an out of borough placement. So I think to be honest, the answer is probably in the material that we've covered, but in particular in those paragraphs of the code about minimizing disruption. It includes things like disruption to employment. Obviously, not everybody can work remotely like we all are today, but that might be a factor to consider for certain clients, whether they whether they can actually still do their jobs if they've been moved out of borough. But yeah, I think the answer is basically in the materials that we've covered in terms of employment, as opposed to education or other factors that we've specifically mentioned.
Where someone has been moved into temporary accommodation out of borough, what are the time limitations in challenging that?
In principle, you're often entitled to request a suitability review at any time. So unlike, for example, a priority need decision, there's not a once and for all cut-off point for requesting a suitability review, particularly if something changes, particularly if, for example, another child is born or educational needs develop or something of that nature. It's easier to persuade a local authority to carry out a suitability review. But it's always good, if you think you've got a strong case, to request a review of the accommodation as soon as possible after the offer has been made and within the time limit that would apply to an ordinary statutory review. And then you, of course, have your 21 days to issue a county court appeal.
Someone mentioned that the Gowie case mentions and dismisses access to faith schools. Are there any cases that specifically mention access to places of worship?
There's not. I had a really interesting case recently where the applicant was a persecuted Sunni Muslim, and it was suggested that she should go to the local Shia mosque because that was all that was available, on the basis that they're sort of the same thing, which was an outrageous thing to say. And unfortunately, that settled on the day of the hearing, so I don't know what the answer is. But having gone back and looked at the regulations, I was surprised that case was defended as far as it was, because one of the things you have to do as part of the regulations is ensure access to services. And if you can't make sure that someone can attend mosque, then regardless of any Article 9 point, which might be difficult to run, then there should just be a regulations point about, well, a mosque is a service, a faith group is a service. You're in breach of the regulations if you haven't at least had regard to the fact that I can no longer access that service now I've been moved.
There's also, that's kind of reflected in the code as well, isn't it? I was just looking at it while Nick was giving the proper answer, but 17.57 authorities should avoid placing applicants in isolated accommodation away from public transport, shops, and other facilities where possible. So you might well argue that a particular place of worship or something similar might amount to a source of support, or something that makes your client isolated if they can't access that anymore.
If a late review request is made, should the local authority look at the situation at the point of the late review, at the point the late review is requested rather than earlier?
So assuming that the applicant has accepted the accommodation and has actually moved and hasn't rejected it and lost their homelessness duty, then yes, you're always looking at the facts as they stand at the date of the review. So again, that's really useful for things like what's gone wrong. If the child is particularly suffering, failing to make friends, become withdrawn, which are very, very common things to happen, then you'll want to be saying that. And ideally, you'll want something from a social worker, something from school staff saying, look, this kid is not coping in Middlesbrough or wherever they've been placed. I should say, by the way, no disrespect to any of the places we mentioned today. I'm just saying out-of-borough placements are a serious thing, particularly somewhere where you're not familiar with.
When moved out of borough, does it mean that the person loses their place on the allocation scheme in temporary accommodation?
I think you'd have to look at each individual allocation scheme, really. I'm not sure there's a general answer we can give to that, unfortunately. I mean, some allocation schemes will say that there's a residence sort of condition, a kind of proximity condition. But apart from that, yeah, I think it would just depend on the policy in particular, I'm afraid.
If a person was discharged into the private sector historically without the enhanced suitability checks, could failure to meet these standards be grounds for a fresh homelessness application?
It would be an ugly case if they've refused an offer and had their duty discharged, and it later transpired that the enhanced suitability criteria had not been satisfied. Then yes, notionally, but it would be an ugly case. You do sometimes see these in intentionality cases, and it's always difficult and confusing when you're having to piggyback off the lawfulness of an earlier decision, particularly if it's to a different and new local authority. But it can happen, yes. It's not easy.
I mean, I think the other way to look at it in terms of that particular client wouldn't be to run it as a failure to meet standards kind of argument. You might be saying that the accommodation that I'm now in, regardless of the decision you made earlier, is unreasonable for me to continue to occupy. So in other words, rather than attacking the previous decision to discharge, you'd run it as if you were approaching for the first time and saying that the property is unreasonable for me to continue to occupy because it's got mold or because the electrics are unsafe or whatever it might be. So that might be the way to try and tackle
that. Do you find the lack of successful appeals to placements in the north by certain London and Southeast authorities surprising, or is this just a symptom of councils being rationally able to say that they couldn't find anywhere closer?
I think with great respect, you're asking the wrong people, because we only see the cases that go wrong. I'm sure that many of you are winning these challenges every day in cases that never ever cross our desks. It's always disappointing when these cases fail in court, but I imagine that a lot of them are succeeding, and that's down to your hard work.
I think that's true. I think I would add to that from our London-centric kind of perspective, at least as practitioners, we have the very great fortune and privilege of being surrounded by, not surrounded, that sounds like a bad thing. There are lawyers in London where there may not be in other parts of the country, I think is the other part of that sort of phenomena. So it is harder for somebody in the Northeast to find a legal aid housing solicitor who can bring a challenge. So that may well be why there are fewer reported cases involving local authorities outside of London and the Southeast, because there are fewer lawyers outside of those areas, unfortunately.
If a woman is on maternity leave and she's moved to accommodation that's far from her work, is that something that you've seen before and challenged? Would you have any comments on that particular situation?
So one of the principles of suitability for accommodation is that the local authority is obliged to consider how long somebody is going to be in that accommodation for. And this is another part of a Hale judgment, where she said that accommodation that might be suitable in the short term may not be in the medium term or the long term. So for somebody who's currently on parental leave, maybe, staying somewhere for a month or two whilst they're still whilst they're still off work might be okay for a month or two. But when they're coming towards the end of their maternity leave, maybe it's no longer suitable because of employment considerations. So it's not necessarily the end of the road there. It's about the obligation to consider whether something that might be suitable in the short term might not be so suitable in the medium or longer term. So it might still be something to work with there.
Okay, I don't think we have any further questions, unless anyone wants to ask anything now. Someone said, thank you so much for sharing your knowledge. It was very insightful. Okay,
well, if you enjoyed that, then can I just finally say that the new edition of Housing Allocations and Homelessness is due for publication on the 4th of December. So there's plenty more where that came from.
Great. I think I'll conclude today there. So thank you both very much. That was really helpful for me. So I'm sure very helpful for all of our many attendees. Thank you very much for joining us today.